Cuyahoga County Court of Common Pleas to show you a sentencing of a man who's already pleaded guilty to felony charges of shooting a 10-year-old. Now, I do have to say, right there we see our defendant, George Zadek Jr. He's already pleaded guilty to 1 count of child endangering, 1 count of assault. Last February, he shot a 10-year-old in a home in the Old Brooklyn neighborhood. That 10-year-old did survive. Let's be very clear, the 10-year-old survived. That's why we hear the charges of child endangering and assault. But we never found out exactly the details around who the 10-year-old was, and was this an accident? Was this a fight? Was this intentional? Let's take you live now to the sentencing of George Zadek Jr.
Good morning, Your Honor. Mary Catherine Corrigan on behalf of Mr. Zadek.
Thank you. Mr. Zadek is himself present. This matter had been set for sentencing 2 days ago, but was continued on the court's own motion in light of the defense objection to an unsigned, undated letter purported to be from Becky Zadek, the defendant's wife. Defense counsel noted at the time that she had no corrections or additions to the January 2nd, 2025 pre-sentence investigation. Would the state like to be heard at this time?
Yes, Your Honor. Thank you. Your Honor, I'm showing defense counsel the signed letter.
Thank you. To the left, it appears to bear the name Jacob Zadek.
That's correct.
Was that to function as a witness, in essence?
That is the victim, Your Honor.
I see. This is undated. Were you present when this letter was signed?
A member of our office was. I, as the court suggested, sent out an investigator.
Do you know on what day it was signed?
It was signed yesterday.
Thank you. Would the state have any objection to my dating it then January 7th?
I do not.
Would the defense?
We would just ask that you dated it upon agreement of the parties.
Of course.
Thank you.
I will do so. Thank you. And I have now done so. Would you like to be heard, Ms. Corrigan, as to sentencing?
Yes, Your Honor. Thank you very much. Judge, I think in this case, a community control sanction is more than appropriate. This was a horrific accident that changed the course of this family's life for an extended period of time. However, it is nonetheless an accident. Your Honor, if you refer to the last line, the last paragraph of the letter written by Becky Zadek, you'll see that Jacob's wishes are that his grandfather...
Just a moment, please. Off the record. Okay. Will the camera remain silent from this point forward?
No. Okay.
Will the camera remain silent from this point forward?
Yeah.
Very good. Thank you. Back on the record. Please continue, Ms. Corrigan.
Thank you so much. Your Honor, if you refer to the last paragraph of the letter written by Becky Zadek, but also signed and I would argue adopted by Jacob Zadek, Jacob's wishes, the victim, the actual victim in this case, not the victim's grandmother, the actual victim in this case, wishes, considers my client to be his father. It appears that he forgives him. He wishes for their family to be reunited and for his father not to go to prison. Mr. Zadek has some issues. I don't dispute that. He has a prosthetic leg. He is not a well man. He has, however, been on bond to this court for an extended period of time since 2024, mid to early 2024. Your Honor, he has appeared at all pre-trials. I have never lost contact with Mr. Zadek, and I think that is something that would extend to your community control department. Your Honor, Mr. Zadek cares about this child. That's why he pled guilty in this case. This was an extremely triable case. But he didn't want to put Jacob through the process of having to come in and testify against him. He is not young. We do not believe that he would live through a prison term. I think that even a 18-month prison term would possibly turn into a life sentence given his host of medical issues. He is extremely remorseful that his conduct in allowing that firearm to go off and hitting his grandson, who I do believe that he and his wife have adopted after his biological mother, their daughter, had a host of issues. So it is kind of a somewhat complicated family tree, Your Honor. Well, I think they're biological grandparents, and this was, on Monday you said, do you dispute even the first line of this? And I said, I'm not certain because there's this element of adoption. I do believe they've adopted this child. Is that correct?
Yes.
Yes, they've adopted this child. So while they're biologically his grandparents, they're legally his parents. And ultimately, this was an accident. I don't even think the state disputes that this was an accident. It was charged with a non-purposeful mens rea in the code section that was elected. This was a horrible accident. This child was shot due to a gun, being in the house, being not safe. Your Honor, I take great issue with, and I do believe that we're in an awkward situation because we've addressed this letter. We addressed it on Monday. Omar approached, it's been signed, we've addressed it today, but my understanding from Monday was it was the state's intention to read that letter into the record, but I've had the opportunity to read it. I know the court has as well, and if it's okay with the court, I'd like to address the letter at this juncture.
You may.
Thank you. Your Honor, I do take issue with the entire first paragraph of that letter. I understand that Becky Zadek is concerned for her son/grandson. However, whether or not my client has a heroin problem really doesn't bear any sort of bearing on this case with a non-purposeful mens rea. My client has been on bond to you, and it did appear from the PSI that there was one positive test for amphetamines. I did not see any positive tests for any of the opiate family. Your Honor, he has been near flawless, but for the single positive for amphetamines that occurred in late December. Judge, I do think that he has issues. I am not standing here saying this is someone we should just set free. This is a person who has some serious issues that could very much so benefit from a community control sanction and the programs available to our community control, the adult probation department. I do not think that his history, along with Jacob's wishes and his issues, give rise to the level. I'm not even sure that with a single cycle CCH, he would be accepted to the community-based correctional facility, which is what Becky Zadek was asking for. Your Honor, he'd like to go home. He'd like to be reunited with his family. We would ask that the court allow him to do so. We think that it is appropriate. It is in keeping with the wishes of the victim under Marcy's law. And Your Honor, it's my understanding that this low-tier felony of the 3rd degree carries with it neither a presumption for prison or a presumption against prison. But it is our position that today we have overcome, or not even overcome, we've, I think, tilted the scales of justice to demonstrate that a community control sanction would be appropriate. We have a man that has consistently appeared for court. We have a man that's had near flawless performance on bond. We have a man with a minimal, although existent, criminal history. We have a man whose victim wants him to get a community control sanction and would like to reunite their family. And we have a man who didn't hesitate to accept responsibility. He stood right here, I think, at this very table and said, guilty to this child endangering charge, because he had a weapon. It was in an unsafe situation in their home, and it resulted in his son being shot. That's why he entered this plea. That's why he's accepted responsibility. But it also is why a community control sanction is more than appropriate, Your Honor. Thank you.
Thank you. Anything you wish to add, Mr. Zadek?
No, sir.
Thank you. Would the state like to hear it?
Please. Your Honor, I'll start with the letter. And I spoke with Ms. Zadek as well. She indicated she did not wish to be present, but she was comfortable with me reading the letter into the record.
Very well.
On her behalf.
You may.
My name is Becky Zadek, and I am George's wife and Jacob's grandmother. Jacob was shot in the stomach. My other grandson called me and told me that Paul had shot Jacob accidentally, and he was on his way to the hospital. That scared me to death, because by the time I got to the hospital, Jacob was in emergency surgery. I didn't understand what was going on. I only knew he was shot in the abdomen. I was scared he was going to die, and I didn't know how serious this was. After sitting there for 2 hours, a surgeon came out to talk to me. They told me they had to reconstruct Jacob's intestines. The bullet had bounced around, and they had to remove some of his lower intestines. They also told me the bullet came out his back and had just missed his spine. They told me he was going to recover and needed to be in the ICU for about a week or so. Jacob was in the hospital for 2 weeks. Since this happened, Jacob has not been the same. Before the incident happened, Jacob was a hyper kid and a happy kid. He loved life and enjoyed playing sports, video games, and coloring. But he has grown much angrier. When Jacob gets into a fit of rage, he tears up the whole room. He puts his head through the wall and breaks things. When Jacob is like this, it is hard for him to calm down. I feel this has bothered Jacob, and he doesn't trust me or the others like he did before. It bothered his mental health. Jacob is not the same kid. He has so much anger, and he does not know how to express it. It's hard for me to handle Jacob, and I feel stressed. I only have the use of one arm, and I can't get around like I used to. I have caregivers to take care of me and help me with the kids. I should have my husband and children helping me, but I don't, because my husband cannot put down a habit, as he chose this over his family. I want to tell George this is your fault. You did this to him. I told him time and time again to stop using heroin. I even gave him ultimatums saying if you don't stop using it, I was going to leave you. He didn't care what I thought or how it affected our grandchildren. Even though I am angry, I don't want George to go to prison. George is in poor health, and if he goes to prison, he will die. I want George to get treatment for his substance use and mental health. I want George to go to the community behavioral correctional facility so he can get the help he needs. I want him to complete it and go on probation. I believe if he goes on probation that he won't use because if he does, it will kill him. We have lost too much family to drugs. We lost our daughter, Nina, to a heart infection, which is related to heroin use. We lost our nieces, Charlie and Tracy, to heroin. I don't want another loss. Jacob also wants me to share his thoughts about his grandfather, who he calls Dad. I want my dad to get help. If he goes to jail, he will die. I don't want him to die. I want him to get better. I miss my dad. I want to see him and be a family again.
Thank you, Mr. Stevens.
Your Honor, this is not a case where it's just an unsafe situation and the gun happened to go off on its own accord, which seems to be the framing that the defense is making in their pitch to you. This case is about the defendant who picked up a loaded firearm and in front of a witness who would have testified that the defendant was showing the victim how to, quote unquote, go around a corner with a firearm. And that it's not like you see in television. And as he turned towards Jacob with the firearm, he fired. And Jacob was shot at such a close range that there is burn patterns from the gunpowder on his stomach, on his hands and fingers, as if he was reaching out. This little boy is forever going to be without a part of his body. Part of his intestines were removed, and nothing will change that. He is lucky to survive. He is lucky we're here on just a felony of the third degree and not a manslaughter case. The state isn't here arguing that the defendant intended to shoot his grandson. Whoever shot him, he did. And he needs to be held to account for his actions. He chose to pick up that gun. He chose to pick up a gun that was loaded and pointed at his grandson. And he fired. He pulled that trigger. That was his choice. The defense said that they allowed the firearm to go off. No, and the firearm just doesn't go off on its own. The trigger has to be pulled. And the defendant is the one that did that. This child will never be the same. And not just because of the missing organs, but because of the mental impact that having a person that he looked up to so much, that he called his dad, who he loves with all of his heart, hurt him in such a traumatic way. That's something he will always have to live with. And while the state removed the firearm specification so that it's not mandatory the defendant goes to prison, the state adamantly believes the defendant should go to prison. We do believe a term of 36 months is appropriate in this case. And we are asking this court impose that term of incarceration.
What jail credit, if any, is your client now entitled to? Ms. Gordon?
I don't have that number, Your Honor.
Ms. Zadek? Mr. Zadek, were you held at any time in custody?
Yes,
For how long?
a week.
7 days?
I think it was 6.
Does the state have any information to the contrary?
No, Your Honor.
Were you appointed or retained, Ms. Corrigan?
I was appointed, Your Honor,
Thank you.
but I would like to respond to the state if possible.
You may.
Thank you. Your Honor, I would just indicate to the court that this matter did not proceed to trial. This isn't a sentencing after a trial where the facts are in dispute and the state is free to argue what they want and I'm free to argue what I want. This is a sentencing after a plea that the state of Ohio agreed to. Mr. Sadiq is specifically asking for something that his victims do not want, which is what more than absolutely allowed, Your Honor. But I'd highlight that both of these, the victim himself wants to be with his father. He wants to reunite their family. And in the same vein, the victim's custodian does not want my client to go to prison. So I'm not entirely certain what brand of vigilante justice the state of Ohio is attempting at this juncture to ask for a maximum prison sentence after the letter that they just quite excellently read into the record. That being said, Your Honor, it is our position, it has always been our position, and it will continue to be my position until the day I stop practicing law, that George Zadek did not purposely shoot his grandchild. If he had purposely shot his grandchild, if he had pulled that trigger, we would not be having this conversation today. We would most assuredly not have been having this conversation today. I'm not even certain that I think the state of Ohio, in good conscience, can argue that he purposefully shot his grandchild or pulled that trigger. It is just, I want this to be very clear, consistently been my position and my client's position that this was an accidental gunshot. And was it acceptable? Absolutely not. But was it purposeful, as was just seemingly argued by Mr. Sadiq? Absolutely not. Thank you.
Thank you. A moment, please. Corrigan, if you know, is the Department of Children and Family Services involved at all in the family situation?
The CCDFS did do an investigation, Your Honor. We did, Omar and I did. We subpoenaed the CFS records and we reviewed them together.
Do they have any ongoing role in the family?
I do not believe they do, but I
Mr.
would
Siddiq?
defer to Mr. Siddiq.
I believe that they are no longer involved since the defendant is not in the home and would not be in the home.
Thank you.
Judge, if I may,
You may.
although I certainly defer to Mr. Siddiq as to whether or not they had ongoing involvement, I believe the court may or may not be aware. I have practiced in juvenile court a fair amount over my time as a criminal defense lawyer. And CFS doesn't simply close a CFS matter because a criminal no contact order exists. They would have proceeded through their portion and either terminated his rights, determined that there was no need for ongoing services, but simply because a criminal no contact order, which removed Mr. Zedek from the home, existed, would not have been grounds for CFS to cease their involvement. Thank you.
There would earlier been a capias in this case, as I recall. Does the state have any objection to that capias now being lifted?
No, Your Honor, I believe we removed that capias on Monday.
Oh, thank you. Yes, right you are. Thank you. Before imposing sentence, the court notes for the record that it has considered the record itself, the relevant, material, and competent statements made here today, the victim impact statement read into the record by the prosecutor, the defendant's prior record, and the nature of the offenses. The court must and has formulated its decision based upon the overriding principles and purposes of felony sentencing, namely, to protect the public from future criminal acts by the defendant or others, and to punish the defendant using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on the state or local government resources under Revised Code 2929.11a. To achieve these purposes, the court has considered the need for incapacitation, deterrence, and rehabilitation. The court must and has also considered the seriousness and recidivism factors relevant to the offense and the offender pursuant to Revised Code 2929.12. The court must and has determined that the sentence being imposed does not demean the seriousness of the offenses and the impact it had on the victim, and is consistent with other similar offenses committed by comparable offenders. Finally, of course, the sentence is not based upon any impermissible or irrelevant factors, including but not limited to the race, sex, age, national or ethnic origin, sexual orientation, gender identity, or religion of the defendant. Do you understand all of this, Mr. Zadek?
Yes.
This is a very difficult case, even a heartbreaking one. It illustrates the terrible toll that gun violence takes on American society today. About 100 people die a day due to gun violence. Often it's accidental, as the state appears to concede is so in this case. The state acknowledges that you did not mean to shoot your grandson. It was, however, an extraordinarily careless act, an absolutely outrageous, even shocking act, and a betrayal of the trust that this child had placed in you. Neither your wife nor your grandson, the child victim, wish you to go to prison. We could easily have been here, however, for a homicide, as counsel alluded to before. Guns are not toys. Guns are not something to make casual displays of. You denied any drug or alcohol abuse or any mental health issues at the time of your plea before me. Mrs. Zadek's letter indicates otherwise. The pre-sentence investigation report indicates otherwise, with your substance abuse history indicating especially amphetamine and methamphetamine use, with no date after which you stopped using it. Mrs. Zadek suggests a term in the McDonald Community-Based Correction Facility, or CBCF. The state advocates for imposition of a prison sentence. I'm not convinced that either would be the best approach in your case, sir, without in any way minimizing the seriousness of your conduct. And with some reluctance, I believe under the circumstances, placing you on a term of probation with strict conditions is the best way forward. The risk assessment summary contained in the pre-sentence investigation report showed you at medium risk for reoffense due to criminal attitudes, behavioral patterns, peers, and substance abuse. It showed you at low risk of reoffense due to family, social support, education, employment, and finance. It showed you at high risk for reoffense due to no factor. I hope that is accurate. On a charge of endangering children, a low-tier felony 3, and assault, a misdemeanor of the first degree, I'm going to place you on probation, that is community control sanctions, for a period of 5 years. You are hereby given a jail credit for 6 days already served. Do you understand? You will be subject to basic supervision by the probation department. Do you understand?
Yes.
You will perform 200 hours of community work service. Your offense was not just against this child, but against the community itself as a breach of the peace. So you're going to give back to the community by performing 200 hours of community work service. The kind of work given to you will be appropriate given your physical condition. Do you understand?
Yes.
You will be subject to regular drug testing. You will enter and complete outpatient treatment for mental health and addiction issues. Do you understand?
Yes.
You will be subject to task case management. They have a lot of experience at helping people with these issues. I encourage you to lean on them and take advantage of the services offered. Do you understand?
Yes.
I will require that you attend 3 AA or NA meetings per week, having obtained a sponsor and verified. If the probation department becomes convinced that this is not necessary, they may let me know. If you believe it is not necessary, you may let me know in writing, and I will reconsider. But I think for the moment, knowing what I do about your case, knowing what I do about your situation, that is appropriate. Do you understand?
Yes.
You will enter and complete the CCW or carrying concealed weapon program. You need to understand, down to your bones, the terrible toll that gun violence takes on American society. From this moment forward, you must have nothing to do with guns. Do you understand that?
Yes.
It is not just because it's a good idea. It's not just because it may keep a similar accident from happening again. It's not just because it may save your life or that of somebody else, but because it is the law. Do you understand?
Yes.
As you are indigent and qualify for the appointment of counsel, I waive costs and the supervision fee in this case, so you'll owe nothing out of pocket. Do you understand?
Yes.
Any violation of the terms of this sentence, repeat, any violation, will result in you being brought back before me and facing 36 months in prison and a $10,000 fine. Do you understand?
Yes.
Do you have any questions about this sentence, sir?
No.
Do you believe you fully understand it?
Yes.
Do you think you'll have any difficulty complying with it?
No.
Ms. Corrigan, are you satisfied the sentence is lawful, appropriate, and in the interest of justice?
I am, Judge. Thank you very much.
Notwithstanding the state's earlier recommendation, is the state likewise satisfied?
Yes, Your Honor.
Thank you. Anything further from the state at this time?
Your Honor, is there a sentence on count 2 as well?
This is the same sentence as to both.
Okay, because 36 months obviously is not possible on count 2.
That is true. As I'm imposing a term of probation, what I was speaking of in terms of potential penalties if he's brought back before me for a violation was addressing solely the felony charge.
Gotcha, Your Honor. Is the court suspending any time on count 2?
I'm not ordering any particular suspension at all. I'm simply imposing a term of probation.
I think what Mr. Sadiq is saying is that the 8th District requires a sentence be imposed on both. So if you just wanted to say you're going to impose maybe the 6 days of credit for time served, then you don't have to impose a sentence on count 2. And I would be satisfied with that, and I assume, I don't want to speak for Mr. Sadiq.
I've read Court of Appeals decisions exactly to the contrary, that I'm not to explicitly suspend any time. I'm simply either to impose probation or impose a prison sentence or a jail sentence, but not mix them.
Okay.
Anything further from the defense?
No, thank you, Judge.
Any questions you have for me, Mr. Zadig?
No.
Then we are adjourned. Thank you all.
George, you have to report to probation right now.
Would you please approach Ms. Corrigan?
Yes, Judge.
Dan DeRose with 19 News. As the judge is about to have a word or two with the defense attorney, or at least getting some paperwork for Mr. Zadig. You're watching a grandfather leave a courtroom who, according to his own wife, has a heroin problem or had a heroin problem at the time of the shooting of his own grandson. As it was described by the state, he had a gun and he was talking to his 10-year-old grandson, and the state said he made a motion to the effect of go over there with the gun in his hand, using the gun almost as a pointer. And as he was telling his 10-year-old grandson to go over there, the gun went off. He was standing so close to his gun, the 10-year-old was, that he had burns to his chest and even his fingers and his hands. That's how close the muzzle flash was that went off when the 10-year-old was shot. Hit in the stomach. You heard had to have reconstructive surgery on his intestines, and that bullet exited his back and it narrowly missed his spine. Otherwise, this probably would have had a much different outcome. The 10-year-old did survive. But as you heard in the victim impact statement, the letter from Zadig's own wife, that 10-year-old is now different, that he is an angry child and goes into fits of rage and destroys rooms when he is in one of those rage incidents, and says that that has been sort of a side effect of being shot by his own grandfather. We'll have a complete wrap-up of this and all of the day's news when we start 3.5 hours of news, weather, and sports coming up on 19 News at 3 o'clock. Until then, I'm Dan DeRose with 19. Have a good afternoon.
19 News is everywhere. Download our CTV apps and follow us on social media at Cleveland 19 News.